Uh, Welcome to the second of the webinars, the CLE webinars. So let me introduce our two panelists today. And the topic is child support for children over 18 and college contribution. Gary Borger has engaged in private practice of law for the past 43 years in Cherry Hill, New Jersey, and is presently a shareholder in Borger Matez. His practice concentrates on negotiation, mediation, and litigation of family law disputes. His practice involves divorce, custody, parenting time, child allocation, alimony, etc. And Vincent Celli is the partner of Celli, Schlossberg, DeMeo, and Giusti. In his 44th year of practice, he litigates, mediates, and arbitrates family and divorce matters. He is a 1:40 economic mediator, a mediator mentor, and a domestic violence economic mediator. He's accredited by NJAPM. So, few housekeeping items first. With respect to questions, there will be questions as we go along. Please do not use the chat. Please do not use the Q&A. Raise your hands. I will turn on your mic. You then have to unmute yourself and ask your question. Once the question's been asked, please lower your hand again. Okay, so let me start out this way with sort of a hypothetical. Okay, you're a mediator in a divorce mediation and have reached the point where child support is the topic. The couple say their son will turn 18 just before graduation from high school. They're not sure he wants to do. He might want to go to college, but they really don't know. But they have told him that he is on his own after high school graduation and he should get a job. So, Vincent.
Yes.
What do you tell them? Do you tell them about what their obligations are for college? How do you start that discussion?
Well, because the goal obviously is to avoid litigation, that's exactly where I would start, with what the possibilities might be were either one of them to make such an application, and running through the obligations imposed by the child support guidelines relating to some modicum of support, running through the factors perhaps in Newberg versus Arrigo, the major case on on getting college expenses for a child who has the ability and the desire to go to school, and give them the information on which they can make a decision balancing the thought that the child is on his own against what obligations there might be, not the exact numbers, of course, but just to acquaint them with what their obligations might be under the circumstances. The real difficulty here is we're sort of setting it up for the child to make an application himself, and that just eliminates eliminates most possibilities for continuing mediation.
So wouldn't you just say to the parents, normally in New Jersey, parents have an obligation to send their children to college? Wouldn't you just
No, that's not right.
Okay.
Parents do not. Divorcing parents.
That's what I meant. Well, we're in a divorce.
But
we're in a divorce mediation, but generally.
So the difficulty is one of the questions that we discussed in preparing for this presentation has to do with exactly that issue, so Gary and I had intentions of talking about the disparity between the obligations of an intact family where parties continue to live happily ever after, as opposed to the obligations that can have been imposed by case law on parents who are divorcing.
Okay, but coming back to it, in a divorce situation, where parents are getting divorced,
Okay.
normally, don't they have an obligation to send their children to college?
Well, there's a line, the Newberg versus Arrigo is the case. We're going to be citing a bunch of cases, but just so that it's clear, we're talking about 88 NJ 529, a 1982 decision of the Supreme Court. In that decision, Justice Pollock wrote what I think are famous words: parents of means have an obligation to pay for the college educational expenses of their children, and perhaps, ready for the chill, folks, and perhaps postgraduate education. So yes, they have an obligation.
Okay, Gary,
Yes,
what would you say? Would you say the same thing to those parents?
basically. And in addition, I would say to them, why don't we reconvene and bring your son in? He's 18 years old. He could, as Vince has mentioned, file an application on his own to compel both of you to contribute to his college education and his support needs going through college. He's a necessary party here. Why not bring him in and the three of you talk and see what you can work out?
Okay. So you've had this discussion and they say, okay, we're reconciled to the fact that we're probably going to have to send our son to college. Discuss what happens with respect to child support. They were assuming child support was going to end at 18. Now the child is going to go off to college. What happens with respect to child support, Gary?
One of the first things I tell them is, let's see if the two of you can agree on what the child needs to make it from September through August, looking at all of his needs. And I would give them an expense statement, which is basically what's called the budget portion of the CIS, and tell them to go home together, maybe with their son, and on a line item by line item basis, fill in what they anticipate he's going to need. If every month of the year were exactly the same as every other month, take the annualized expenses, divide them by 12, take the weekly expenses, multiply them by 52 and divide by 12, and come up with a total bottom line number of what he needs to get through the year based on what you have available to contribute to him and what he himself might be able to make during the summer, during school breaks, or maybe even during the school year. This is assuming the child is away living at college as a full-time residential undergraduate student. And then let's look at those expenses and talk about how we can fairly divide them among the three of you. And again, if you wish to do it, bring your son in next time. Let him participate in this. It's all about him.
Okay, Vincent?
Under those circumstances, I might also encourage them to take a look at the opportunities that are available at the local community college in their county. Because for a child who is unsure of what their future holds, perhaps the way to do it is to ease into a college education. And for that purpose, the county college provides a much cheaper alternative, which may make college more, number one, attainable, and number two, enjoyable for the child.
But let's stick with child support for a minute.
Okay.
Child support. With respect to child support, it sounds like Gary is taking the approach that you're going to do a budget.
Yeah. Well,
right? Do you
have to know what the child's expenses are, separate from those of the parent with whom he's residing or will be residing.
Okay, is that the way you always approach child support, which is you do budgets for the child?
Well, when you're talking about these issues, yes, you would do that. If because the child support guidelines don't apply to the case of a child who is going to college and living away from home. For that purpose, you have to take a trip through Appendix 9A to the child support guidelines to see what steps the parents and the mediator assisting the parents have to go through.
Okay, well, let's step back a little bit then. Say that the child's going to go off in a year to college and they need to establish child support for this next year before he goes. In that case, are you doing the budgets primarily to establish the child support?
Well, you see, I'm sorry, maybe I don't understand the parameters. Is the child still in high school when
Still
this
in high
happens?
school, he's going
Okay.
to go to, now
Well-
you establish the baseline child support. Do you do that by budget? Or do you do it also by running the guidelines? Which way?
Well, I would start with the guidelines just to get a sense of where the numbers are likely to be based on the incomes of the parents, at least during the time until the child graduates and then is ready to move on to college.
Okay, Gary, do you do the same thing?
I would, and depending how close you are to college, I would probably urge them at the same time to work on the expenses of the child for them to establish what, if anything, is going to be paid from one parent to the other when the child is away at college. Or as an alternative, I throw out the idea that sometimes parents agree to fund the child's checking account each month, may in a different amount from each parent, maybe depending on their respective financial circumstances. And is there also going to be a payment from the parent earning more money to the parent earning less money? Where do you think the child's going to stay when the child is home from college during the summer and school breaks, which is roughly 40% of the year? And have them thinking both payment now under the guidelines possibly, and then changing that payment at the end of August when the child leaves for college based on what they've agreed to.
You know, Carl, it's important to know what the child's expenses are going to be. I mean, in a wild card kind of way, if a child is not going to be living with either of the parents, then this takes on a very different.
But I'm still trying to get to the baseline, which was child support before college.
Yeah.
Okay.
I'll stand by my earlier answer.
Would you say that most of your clients, I'll ask you for this first, Vince, base it on the child support guidelines or on some independent calculation using budgets, et cetera?
Most would defer to the guidelines, I think, because except in extreme income cases, the guidelines give you reasonable numbers that you can use both for the baseline during the time that the child has to go until graduation, and then as a touchstone for modification to take into account who's actually paying what college expenses.
Okay, Gary, is that your experience too, that most of your clients use the child support guidelines?
Yes, most of them have heard about the guidelines and want to know what is the result of running the guidelines in their situation. So for that, I'll run the guidelines, but I'll tell them they're not bound by the guidelines in mediation as they might be if they were in a courtroom before a judge. And by the way, if the child is going to commute to community college, I would also tell them that in that case, they can continue the guidelines amount, that's consistent with the law if they wish to do so. But I would also say to them, we now have new variables involved. Your child is out of high school, he's going to community college. If he's going full-time, he's still un-emancipated under the law, although that's your decision what you want to do. If he's going, even going full-time, he may have a part-time job and be able to contribute to some of his own expenses. But he also has maybe enhanced expenses. He has possibly a car insurance, car maintenance, fuel. So with all of that, that's why mediation is so beautiful. They can sit and analyze it for their particular situation and do what they think is best and most fair.
Okay, but let me go back. I want to stick with the child support part first.
Okay.
Okay. So you've now established the way you do it is child support when the child hasn't gone to college yet, living at home. You've done it by the child support guidelines, right? Okay. Now comes the time where the child is going to go to college, right? How do you explain to the parents what the various options are with respect? Just stay with child support for a minute, okay? What happens if the child goes to college? What happens if the child stays home? What happens to child support when the child actually goes? Vince?
Well, the child attending the local community college and living at home is actually the simplest of the many possibilities, because as Gary said, the guidelines can be used in that case, specifically authorizes the use of the guidelines for the purposes of supporting the child while the child lives with one of the, theoretically, lives with one of the parents, and an amount of child support passes between the parents. That doesn't prevent the child from working and earning and contributing to his or her own expenses. And it's really the simplest case. It becomes more difficult when the child resides away from home at a school, and then that brings us into considerations of less expensive public schools, less expensive private schools, more expensive private schools. And that, I think that's really where the big fight occurs.
So just the child support, if the child goes away to college, you've got to relook at the child support part.
Yeah, and again, that's right in, it's Appendix 9A of the guidelines, paragraph 18 talks specifically about the interplay between child support and college expenses.
Okay, now Gary, even though the child support guidelines say that, you know, they say that you can use the guidelines if the child resides at home while going to college, and they don't apply if the child goes away. The parents can decide whatever they want to do, right? They can use the guidelines and just say, we're going to do it this way, or we're going to do it that way.
Exactly. As has been mentioned before in these sessions, the touchstone of mediation is self-direction and self-determination. So they can do whatever they want. My job as a mediator, as I see it, is to give them options they may not have thought about, and to use some reality testing with the proposals they come up with.
Okay, so
not
the guidelines,
not to give them the answers, but to at least throw out questions to them.
the guidelines really only talk to what the court does.
Right.
The matter is before the court, what the court actually can or can't do, right?
As long as the parties meet the income requirements, then the guidelines presumptively govern.
Okay, what do you mean by the income requirements?
Well, child support guidelines apply only up to a certain level of net income, 187,000 or something similar. If the parties are in what is called an extreme income circumstance, meaning a lot more or a lot less, then of course you have to take that into account in terms of who pays what.
And
So-
just so it's clear, that 187,000 is combined net parental income, that is after taxes.
Right.
Okay. And so what that guideline says is if your net income of if the net income of the parties is more than $187,200, you're supposed to set a base amount and then talk about other amounts for child support, right?
Right, a supplement.
And the court is not supposed to extrapolate beyond 187,200, I believe.
Right,
But
That's
the
right.
parents could. The parents could decide, well, we're going to do that.
they can. There was a judge years ago who looked at the guidelines when there were percentages of net income and also absolute dollar amounts. And the judge said, well, it looks like at the top of the guidelines for this couple, it's 14%, I'm just going to say arbitrarily, of their net income that goes for child support. And if we go down by 50,000, it's 16%. So if I extrapolate above the 14,000, maybe 14%, maybe I'm down to 12% for this couple, and that's what I'm going to do. And the appellate division reversed the judge, saying that the guidelines were established and built upon a doctoral study by a sociology student, a graduate student, who used a particular set of families with a maximum income, whatever it was back then, I don't know, 56,000 or something, Vince, it was
Right.
pretty low.
Probably.
And above that, there's no data to support using the guidelines for higher incomes. So the parties, like you said, Carl, they can do whatever they want. If they want to extrapolate because it's easier or they feel it's fair, it's their determination. No judge is going to set aside the agreement based on what they've decided, because a judge is not going to read through the agreement when somebody eventually puts a divorce through and decide whether it's fair or not and rubber stamp it. All mediators should be aware of that.
All right. I had a client once who was a mathematician. And what he did was he took all the data from the guidelines, the income and the actual support amount, and he determined that really it's a straight line. And I don't know if you remember, but the amount used to be higher than 187,200. It was 200 and some thousand, and it was a straight line between 187 and the 200 something. And he just kept taking that as a straight line. And I told him, you know, what the guidelines said. He said, well, that's what they wanted to do. And since he wanted
Somebody probably overpaid.
but that's what he wanted to do.
Well, yeah, but that's Gary's point.
And what you're saying is that's fine. They can,
Right.
the person can determine whatever they want.
And interestingly, when the guidelines, I think under federal law, are required to be reviewed by each state. Is it every 5 years, Vince?
I thought it was every 3, but
No, I think.
you're right. It is, there is a regular requirement, if only for adjustment in accordance with inflation.
Right, if you want to get, every 3 years, there's the cost of living. It already used to be the biennial cost of living every 2 years.
Right.
But I think that the federal law requires for the states to get federal money under Title 4D, they have to review the efficacy of the guidelines every 5 years. The last time it was done, for some reason, when you had more than one child, the additional amount, the marginal amount added for a second, third, fourth, or fifth child went way down. And so people with 2 or 3 children were really getting so much less than people had been getting before the guidelines were reviewed for the same number of children and the same incomes. And I don't have the answer as to why, but be careful with the guidelines. They may not be fair to a couple, may not feel they're fair in a particular situation, but I think it's not bad to run them, give them the answer. It may be that a judge will require that the guidelines be attached to their agreement with an explanation if they're going to deviate, as is supposed to be done.
Okay.
It also wouldn't hurt to have a statement of the expenses for the child upon which they base their decision to pay this much or that much. Again, as Gary said, to back up the decision for review by the court if it ever comes to that.
Earlier, Vince, you mentioned the Newberg case.
Yes.
It sets out, I think, 12 factors that have to be looked at with respect to college. Do you normally, in a mediation, pull out those 12 factors and go over them with the parents? Or do you just reference the case, or what do you do?
If you don't mind, Carl, I'm going to attempt to share a chart with the there. Hopefully everyone can see the
No.
No, not yet.
not yet. You know, I have
While Vince is doing that, I'll just throw out what
Yeah.
I do is print out the Newberg versus Arrigo criteria, the factors, and give them to the people to take home to read over and tell them if it were to go to court, these are the factors a judge would have to apply in determining what your contribution may be to your child's college education expenses.
Okay.
And then they'll read them and say, well, this is confusing. This makes no sense.
Right. So generally, you don't get many questions.
that's right.
That's right. So you hand it out.
You have to
it's information.
interpret the questions for the client.
Right.
It's like the alimony factors. You say, here they are. And they say, well, that's nice.
What does it mean?
Okay.
What does it mean to me?
Yeah, that's right. How much is it going to cost me?
Right.
Okay.
What's the bottom line here?
So once they get to that point, they more or less accept that they're going to do it. What are the, so if they're above the 187, 200 for net income for the couple, what are the additional types of expenses that people should be considering in establishing child support?
Well, actually, those that practice is governed by the same statute that provides for equitable distribution. It's 2A:34-23A. And in that section of the statute, there are 10 factors that the judge or the attorneys or the parties have to look at to determine child support, which either is not governed by the child support guidelines or where the income of the parties exceeds the maximum under the guidelines. The very first criterion is the needs of the child. So in mediation or even in litigation, it requires a knowledge of what additional or different expenses a child is going to have separate from those of the parent with whom he or she resides, which have to be addressed. Then it goes on to standard of living and economic circumstances, income and assets of each parent.
But aren't we talking about something more, whoops.
There you go.
Oh, there you go.
Those are the Newberg factors. Okay.
Right.
But I was saying is, doesn't in the guidelines, they mention certain things that could be considered when it's over 187,000, you know, for big major expenses?
Well, in the context of college specifically,
Yes.
the paragraph 18 is instructive because it talks about how, and I'll quote, many costs associated with college attendance, such as room, board, and transportation, are already included in Appendix 9F Child Support Guidelines awards. So you have to break those out in order to address how much more one party should pay, if any, toward the child's expenses, and whether it's directly or in the form of rent or in the form of a payment against tuition. But the guidelines also gives the hint that an individual should not be required to pay more than the an amount that would exceed the payment of intact families in a similar economic situation. So the guidelines is all for, there's a, we just got a question, Carl, did you see it?
Yeah, I'll see if I can handle that.
I'm gonna try this once more. I have, now, come on. There you go. Here, well, I didn't want this particular one though.
Oops.
One of these days, I'm gonna have to learn how to do this, Carl.
Yeah. Okay.
Hopefully,
Okay, I
People
put
can
them in the,
see.
I put them in the chat.
Appendix 9A rather,
Mhm.
paragraph 18 is the one I was talking about, where the guidelines, where it suggests that child support under the guidelines should be modified where there are expenses that that would affect a parent's ability to pay and avoid unnecessary duplication. If a parent pays a share of room and board, well, then they're already paying, let's say, for 9 months worth of a share of room and board. They shouldn't also pay the same amount of child support, which is intended to provide the custodial parent with a payment on account of room and board.
Okay,
So-
so we've now taken care of child support. We've now figured out that what the child support will be when the child stays home and commutes or goes off to college. They figured this out. Okay, now you're talking about college itself. Okay, what do you normally cover with the parents when you come to the college topic? Okay, what are the various items? And do you do that from some sort of template, or how do you do that? Gary, why don't you start?
Okay, just finishing up the Newberg criteria here for everybody. Somebody requested it. Anyway, well, it often depends how close you are to the fall semester. My experience, well, the first step would be to talk about.
Let's backstep. Let me step back. How about if the child is 3 years old?
Okay,
3 years old, and then we have one that's 15 years old, right?
right.
So talk first when the child's 3 years old and you're going to talk about college, and they say, wow, that seems like a very long time away. What do you talk about?
Okay, the first thing is I occasionally have a couple where one of the children probably will not be going to college because of either cognitive limitations or whatever it might be.
Now, this kid is just one 3-year-old, perfectly fine child, but you come to college and, I always talked about college, even with a 3-year-old. Do you do that? And if so, why? And if you don't, why not?
I give them 3 numbers.
No, well, let's Gary first.
I do. I tell them that they have options. One is to not mention it at all, which I don't urge them to do. Number 2 is if they want their child eventually to go to college, assuming he or she has the aptitude and the willingness, desire, maturity, and so forth, in which case they may want to express their intentions with regard to the child. And if they take that route, then number 3 would be to talk about what criteria do you want to use do you want to put criteria into your memorandum of understanding? For example, some people say, we'll just base it on our respective incomes at the time,
Okay.
pro rata.
Oh, great. Let me cut you off right there. Okay. Is that the same thing you would say to the couple if the child wasn't 3, but it's now 15?
I would start the same way and
You
say,
start the same way. Okay.
is the child going to go to college? Yes, we want the child to go to college, and the child wants to go to college and has the abilities. Isn't flunking out of high school, isn't a C- student.
So you approach it the same way. Vince, do you? Vince, do you do the same thing?
Except when the child's 15, I now urge them to consider putting in criteria for how they're going to determine how to share the cost of college. And that's when I bring up Newberg as one set of criteria or factors to consider, and they can deviate from that any way they want.
Okay, Vince, 3-year-old
Well,
versus.
the 3-year-old, I said, and I intended it to be funny, I give them 3 numbers, 5 to 9,
Yeah.
because the real concern, I think, is the fact that the cost of college is far outpacing whatever inflation there is in the current economy. So that if they have the intention, not only do they have to know the Newberg factors, but they also have to have, I think, at least a reference to some source for saving for college. So that's why I might mention the 529. At the point where the child is already in high school, they're already getting the benefit of the high school's curriculum for college-bound kids. I can just thinking back to when my girls were in high school, there was an aggressive program of information for parents about how to choose a college and how to pay for it, just as importantly. So at age 15, we're past savings. Now, I think the focus has to be on how are the parties going to determine what school the child's going to go to. What does their financial picture allow them to do? Are they going to consider student loans? Are they going to consider the trust fund that they hope that grandma set up for the child? That's the point where they have to come to the table with the plan for payment.
Okay. So let's talk to the first point first, which was what school?
Well, there,
And do the,
no doubt, I'm sorry.
do the parents have complete discretion as to what they can do? So even though there's maybe a general requirement to send your child to college, it doesn't specify what type of college. Okay.
Not at all.
It doesn't specify whether the child lives at home.
No,
It's just some education, is college education. So they could say the child has to go to a community college for 2 years.
yeah, they could make that their choice.
Their choice to do that.
Right.
Okay. What do you agree with that, Gary, right?
Yes, although it's not binding on the child, but if the child wants financial aid from their parents and the parents decide we're only going to contribute if your first 2 years are spent at a community college, well, that sort of determines it.
Okay.
See, earlier Gary said that he might bring the child into the discussion, if only because he's planted the thought in the parents' minds that the child does have responsibility, because that's one of the particular criteria in Newberg. I'm not so sure how early in the process I would get the child involved, because I would suggest to the parents that they have to understand what they are capable of doing for their child, and if this might be a good time to mention that they have to keep in mind the rights of kids behind the first child to go to college. There's a case, Black versus Black, that was decided by Judge Lawrence Jones. It's a Chancery Division decision, but there are two very good takeaways from that case. One of them is that the court has the authority to order the parent and the child into some sort of counseling to repair the relationship if it's not the best, because that's the favorite way of a lot of payors to try to avoid paying for college, saying I have no relationship with the child, I don't know what the child's goals are, they didn't include me in any of the planning. But the second piece that Judge Jones said was that you have to make your decisions keeping in mind what your obligations are likely going to be to the second or the third or the fourth child. So it's only when the parents have an idea of what they can afford, what they're willing to do, community college as opposed to less expense public, four-year public school, and so on. That's when you can then start bringing the child in if you're going to do that.
Yeah.
If they want to do that.
I never would have brought a child into a mediation on the basis that, this is the parent's decision.
Yeah.
A child's a child. At 18 or whatever age, do they have an equal say in this? No. If they want to tell the parents about it, that's fine. In my opinion, it was just not appropriate to bring it into a session. But
unless that's the only way you're going to get the clearest statement of the child's thinking. But the parents can certainly relay that to the parties and the mediator.
Right.
And it's the parent's choice in the end anyway, whether to bring in the child. It's not you can't command it.
Right.
Okay. How often do you find that there's a real disparity between the parents as to the type of school? Does one say Ivy League and the other says community college?
Yes.
Yes, you find that often?
Unfortunately, yes, you have the self-made individual who went the community college route, then took 4 years, the second half, third and fourth years at a state university, and is now working and earning a respectable salary, as opposed to the party who thinks that their child is literally the brightest star ever to shine in the heavens and has to go to Harvard. Hang the cost. If I said I've never seen that, you would know I'm lying.
Okay. Gary,
Exactly.
how do you help them work through to a resolution on that when they're so far apart?
I get them to talk about the child's high school career, the GPA, the courses the child has taken, how well they've done, what the child's strengths are, what the child's weaknesses are, the maturity level of the child. Get them to talk it out as parents with one another in front of you, and try to bring them around to some resolution, some common ground, hopefully, that they both can reach. It may be that they arrive at a resolution where the child does 1 year at a community college to test him or herself and show the parents what he or she can do. And they sometimes come in with this preconceived idea that the cost of Rutgers is the limit of what a judge can order, and that's just not true. But they could decide that themselves if they want to.
Okay, let me come back to Rutgers in a minute. How much do you look at the financial resources of the parents? I mean, I can't tell you how many parents came in, they're in their 50s, maybe even early 60s, and they have nothing. They have nothing saved. They've paid for very expensive college educations, expensive weddings, and they're done, with more or less their earning capacity. They're not going to accumulate any more wealth. And with college so expensive today, what do you tell parents who are saying, oh yeah, we're going to spend $75,000 a year sending a child to Georgetown? Do you say anything? Do you suggest they get some sort of advice about retirement planning?
Well, I think the best thing that we can do is to instill in any mediation client the need for realistic goal setting based on the operating facts. It's great that a parent would think that their child is capable of performing at the Princeton or Harvard level, but if the child, as Gary pointed out, if the child's grades are such that the first year at county college is going to be difficult, then they have to look at that realistically and plan accordingly. Carl, you mentioned the parents who've given all to their kids and have nothing left. Well, they've forgotten the cardinal rule, which is you fund your retirement and you borrow for education.
So are you asking, Gary, are you asking them to be realistic in how much they spend with respect to college education because of their own retirement? Do you put it as bluntly as that?
I asked them to, yes, I asked them to consider it. We usually start mediations with them expressing what their goals are, what their anticipations are for the future, what their fears or concerns are, what keeps them up at night, so that we can address those important issues. And if financial security is one of them, as it is in almost every case, number one, they want what's best for their children. Number two, they want financial security. That's almost true of every couple across the board. So when we talk about financial security, that has to take retirement into account. And so I urge them to talk to a financial planner, each of them individually, to get some reality testing and checking of their ideas.
I have to give a code every time I forget to do this. So I'm going to give a code, which I won't forget, which is 1942. 1942. I have another one, so don't let me forget. We only have a few more minutes.
Okay.
So you suggest a financial consultant, someone. Do you also suggest some sort of college advisor?
I do, and I had one who was an attorney who went into the insurance and college advising field and is now retired to Florida, and I don't have a replacement, but he used to sit down with couples and explain to them that they often, the financial aid is not just limited to need-based financial aid, that some of the very well-endowed universities, Ivy Leagues, for example, will give whatever it takes to get a qualified student to attend that university. And so they can sometimes spend less out of pocket for a private university than they would for a public university. But I don't have someone right now to turn to, unfortunately. I lost my resource.
Okay. Vince, do you do the same thing with respect
Yeah,
to
so for parents with the means to who can afford that kind of expert assistance, it's invaluable, if only to help them attain that realistic understanding of what they're capable of doing and how they might be able to fund the education from other sources for a child who has the aptitude and the grades to excel.
Okay, so you're really urging them to be realistic
Well,
about what they're going to be spending.
college debt is increasing at an almost exponential rate. And whether it's the child taking on the debt or the parents taking on the debt, that's probably if not already bigger than the mortgage debt that people have accumulated over time since the 70s, or it's going to be there. And there's a problem that they're going to have to deal with. There's a question there about defining the word means. I'd like to say I can give you an answer about what the word means. That was the language literally right out of the decision in Newberg versus Arrigo. And I think it's a whole lot less than we think it is. Because when a judge takes a look at what constitutes a party's means, a judge is required to look at income and assets. So a parent who thinks they don't have the ability to contribute could possibly learn the hard way that the court has a different opinion based on what they show on their case information statement and what they're capable of borrowing.
Okay, let me go back now to the issue of how you're going to allocate out college expense. Okay, so let me give you an example of husband makes $250,000 a year. The wife, after alimony, is going to be making $75,000 a year. And what are the options with respect that you tell them, options with respect to sharing whatever the college expense is?
The first thing I do is throw out a question. Do you want to share your child's college expenses? And have you talked about it and thought about it? And what do you think each of you is capable of paying to get the discussion going? Now, in some cases, the lesser earning spouse may say, well, he's going to pay it all. He's the one with the higher income. And that spouse says, well, no, I don't think that's fair. I think she should pay something, even if it's not equal. Well, now you've gotten the discussion going, which is part of the job of the mediator. And you start to talk it through.
Gary, Vince, do you do the same thing?
Well, yeah, but Susan Wright just put a question up. Why not look at combined net incomes? Well, you're actually saying, why not run the child support guidelines and take a look at the possible, one of the possible sharing opportunities that the guidelines provide. The difficulty is your example of 250 and 75, that's a grand total of $325,000. That would put them slightly over the guidelines in terms of combined net income, but it might be close enough for those folks to, and they might see the logic of sharing the expenses in respect of their net incomes.
Do you find that most people share in proportion to their relative incomes?
Most people come in with some pretty strongly held ideas. As Gary just said, the wife in this case is probably not going to say, oh, sure, I'll pay half. That's highly unlikely. Whereas he, of course, says, well, why shouldn't she pay half? They're our children. So that's where being able to use something like a combined net income approach really helps. Although for that purpose, you have to know what the expenses are going to be.
But do you find most people do it in proportion to their income?
Eventually.
Okay. Gary, what's
Eventually,
your
most
experience
people
on
do.
that?
Yeah,
What's
I
your
think
experience?
a lot of people do that. But if this is an alimony case, as it sounds like it may well be, then in the alimony portion of mediation, which I would have done after, well, I would have them present their needs on a budget statement of what they need to live to maintain roughly approximately the marital standard of living if they can. So we can always go back to that, where if husband says, in this case, I think we should pay equally. There are children. We brought them into the world. And the wife says, and one question I may throw out, well, how does that impact your ability to live, each of you?
Right.
And
Okay,
let them talk it through.
So what happens in the same situation and the wife who's only making $75,000 says, you know what, that's absolutely right. We should share it equally because there are children. Do you say anything?
I would, at that point, I would ask her to show me what her anticipated expenses are going to be, to show me what her sources of income are, ask him to do the same thing, and then suggest that they compare the net incomes, but ultimately they could agree on each paying half.
So you're urging the person to be realistic, but
Well,
but if the person doesn't want to be realistic,
I can't force realism on a
okay.
on
Same
a
thing
party
for
in
you, Gary?
mediation,
Yeah,
any more
Carl.
than a judge can force realism on litigants.
Same thing for you,
Carl,
Gary?
I think part of the mediator's job is to assist in reality testing for the parties.
Right.
I don't mean we make the decision, the mediator doesn't. But I think we have, that's part of what we offer.
Okay.
Right.
Let me give the second code. It's 1025. Okay. Let me switch now to something you raised early, Gary, which is the Rutgers Rule, the Rutgers standard.
Right.
Describe what that is.
Well, at one point, a judge ruled that Rutgers should be the standard, and that if a parent wants the child to go to a more expensive school, the contribution should be restricted or limited to what the parents would have paid if the other parent would have paid if the child went to Rutgers. And the appellate court ruled that there's no such Rutgers rule in New Jersey, that each case stands on its own and has to be determined based on the child's abilities, the parent's abilities to pay in terms of income, assets, reasonable liabilities, the child's resources, all of the Newberg versus Arrigo criteria. So there is no Rutgers rule unless the parents choose to establish one for themselves.
Vince,
In fact,
when you're going over this with the parents, do you mention anything about whether the parents want a limit on their obligation, not what they necessarily will pay, but on their obligation with respect to college education? Do you mention that when you're talking about college expenses?
I think you have to give them at least the option to think about it, just as you're asking them about how much they want to spend. And I'm asking them to please be realistic in terms of what your incomes are, what your expenses are, because you folks have to live even while Johnny or Janie is attending the school of their dreams.
Okay, so would you state it's something like, first, do you want to have a limit on what your obligation is? Not saying what you'll necessarily spend, because you might want to spend more than that. And if you do want to have a limit, would you want to have a limit, say something like what it costs to attend Rutgers for a year? Would you do something like that?
I don't know. I don't know that I would be quite so specific about what limit there might be. The fact is that when people come in the door, they already have the idea. They already know the statistics that Judge Mayenza just put up on the screen, that Rutgers is $12,000 a semester and the county college is $5,000 for the year. So they have this idea
That
And
was not my experience. My experience is a lot of times parents are kind of clueless. But Gary, do you say that? Would you always raise, do you want to put a limit? And if you do, is it something like what Rutgers would cost a year?
No, I don't propose that. I leave it up to, I'm more of an open mediator in a sense. I'm not as directive. So I'll ask them, have they thought about college? What are your thoughts? Where do you think your child might go? Abilities, finances, and all that. And have you looked into it? Have you looked into the cost of college? And before you come back for the next session, do some homework.
Okay.
And,
I always
and
did
talk to each other if you can. You don't have to limit it to discussions in mediation for an amicable couple.
Okay. I always did raise that as to whether they wanted to put a limit, and if they wanted to put a limit, would they want to limit to something like Rutgers or whatever? And I didn't think that was being directive. I thought that was being educational and put,
Well, it is an option to throw
it's an
out. Sure.
option, just that it's creating an option.
Right.
Okay, quickly, because we're out of time. What problems has the COVID situation created with now students who would normally be on campus, they're now at home doing all their classes online?
well, the difficulty with the COVID impact is that a lot of colleges are flip-flopping on whether they're going to provide an in-school option or a virtual option. So it's very difficult to help folks plan when we won't know until literally, in one case, parents learned the day before the child was supposed to walk onto campus as a freshman, the school closed the campus and declared that all would be learning virtually. Well, the same thing could happen to someone who literally does walk into the dormitory, starts attending classes, and a month from now, the school declares that henceforth their opportunities are going to be limited to virtual learning. It's impossible for people to plan under those circumstances. So while I think you have to educate the client, I'm sure they're hearing a lot of this from either other family members, from other kids in school. If the high school is doing a good job, it's keeping them abreast of all of these changes. I mean, the high schools themselves, one day they could be virtual, the next day they could be in person.
So are you finding, and doesn't have a lot of experience behind it, are people coming back to you and saying, here's my agreement with respect to college, I need to do something, or is this still too new?
I have not seen such a case yet.
Okay, you're not seeing it yet, Gary, either.
No.
I assume if it goes on for a long period of time, people might be starting to think about adjustments to what they're paying.
They might also be thinking about what adjustments the school should be making under the circumstances, but that's a topic for somebody else in a different seminar.
Okay, I have let this run over. Is there anything else you would like to add?
Just thanks for the opportunity to speak on the subject. I enjoy presenting because we always raise new and different questions, causing us to think, God forbid.
Okay.
And I agree. This was a wonderful opportunity to brainstorm, to think introspectively about how we each approach it, and to realize each mediation is a unique experience for everyone.
Yeah, but what I do take from both of you is, at the end of the day, it's the parents who choose, right? Choose what they're due. As mediators, we sort of guide people along, give them options, do a variety of things to allow them to reach what they think is the right decision for themselves.
Yes.
Right.
I agree.
Thank you very much. I really enjoyed it, and it's always fun doing this. I'm sorry for the confusion in the beginning. we had more technical problems today than practically any other time. But thank you and have a great day.
Thank you,
So
Carl.
long.
Bye-bye. Good job, Vince. Thanks.
You too, Gary.